but this is the time and place scheduled for our open meeting. I'd like to start with the roll call. I'm Chair Scherer, and this meeting also present in Reno is Vice Chair Wallen, and let's proceed with the roll call from there. Vice Chair Wallen.
When say here again, you're muted now.
Okay, sorry. This is just like, I'm in charge. I'm taking over the meeting. Okay, all right.
We lost you for a
Got
minute,
that
so.
part. Helping with mission council. Right, I will go ahead and do roll call. Chair Scheer,
Here.
Vice Chair Wallen, here. Commissioner Langton,
Here.
Commissioner Lowry,
Here.
Commissioner Miller. We can't hear you.
There you go.
There, okay, there you go. Commissioner Moran,
Yes.
Commissioner Reynolds,
Here.
and Commissioner Smith.
Here.
The staff, we have Executive Director Armstrong,
Here.
Commission Counsel Bassett, here. Investigator Terry,
Here.
Acting Associate Counsel Hazlitt,
I'm here.
Outreach and Education Officer Harvey, here. And Executive Assistant Saldana. Here. Right, please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Oh, and just for the record, we also have Deputy Attorney General Olson.
Thank you. That brings us to public comment. Executive Director Armstrong, if we received any public comment by email to be read into the record.
Thank you, Mr. Chair. We did receive a public comment from Aaliyah Moser regarding the Devin Reese matter. The commissioners have been provided with that public comment. In summary, she wanted to encourage the board to appropriately discipline Devin Reese, if only to provide him as an example for appropriate disciplinary action to prove to Nevada that ethics is actually meaningful in our state. As I said, the commissioners have received that public comment and it will be added to the file.
Have any of the commissioners not received that particular public comment? Seeing none, is there any other public comment that we've received by email, Executive Director Armstrong?
There is no other public comment that we have received by email.
Okay. Are there any members of the public who are attending in person or virtually who want to provide public comment?
There are members of the public here. If you wish to provide public comment, please come forward to one of these tables and provide it. And I will defer to Executive Assistant Saldana if there's any virtual public comment today.
There is no one that wishes to provide public comment in the chat.
And no one is approaching the table here in Reno.
Okay. Thank you. Let's move on then to item number 3, which is the approval of the August 20th, 2025 commission meeting minutes.
I move to approve.
I'll second.
Is there any discussion? All in favor?
Aye.
Any opposed? Seeing none, the motion passes unanimously. Item number 4 is a discussion and approval of a proposed stipulated agreement concerning consolidated ethics complaint numbers 21-062C and 21-082C regarding Joseph Lombardo, Sheriff, Clark County, State of Nevada. Do any commissioners have a disclosure they would like to make on this agenda item?
I can go first, Mr. Chair.
Please go ahead, Commissioner Moran.
Thank you, Mr. Chair. I'm making a disclosure in consolidated case numbers 21-062C and 21-082C. I am an acquaintance of the former sheriff, having met him on occasion through his service as sheriff and now governor, and my work in the state of Nevada as an attorney. I have known Governor Lombardo in a professional or public capacity for many years, although none of my work directly involved him, either formerly as sheriff or presently as the governor. I would categorize our current relationship as professional acquaintances. Additionally, Governor Lombardo appointed me to sit as a commissioner on the Nevada Commission on Ethics, the term to start on September 1, 2023. Upon the unexpected resignation of prior commissioner, whom I was scheduled to replace upon the expiration of term, my start date as commissioner was reset to July 1, 2023 to fulfill the remaining term caused by the resignation. Under NRS 281A.065, my relationship with the governor is not within the definition of a commitment in a private capacity to the interests of another person. Consequently, the relationship does not require disclosure or abstention under the ethics law pursuant to NRS 281A.420. Additionally, nothing in Judicial Canon 2.11 of the Code of Judicial Conduct requires disclosure or abstention pursuant to the manner of my particular appointment. In fact, Nevada law favors the right of a public officer to perform the duties for which the public officer was appointed and to vote or otherwise act upon a matter. However, in my capacity as a commissioner, I serve in a quasi-judicial role and desire to alleviate any concerns of impartiality. Consequently, I'm disclosing the extent of these relationships. Further, I have reviewed Judicial Canon 211, Code of Judicial Conduct, which lists the types of relationships and events that require disqualification, and confirmed that the presented circumstances do not require disqualification. Moreover, I believe I can be fair and impartial in considering this matter and have no actual or perceived bias. I don't believe my acquaintanceship with the governor or my appointment to the Commission on Ethics by Governor Lombardo would materially affect my independence of judgment or that of a reasonable person in my situation. Therefore, Mr. Chair, members of the Commission, I will be participating in voting on this matter. Thank you, Mr. Chair.
Thank you. Are there any other disclosures? I will disclose, similar to Commissioner Moran, that I have known Sheriff and then Governor Lombardo in a professional capacity only. We do not socialize with each other. And I don't regularly, in fact, my work, I don't think has ever brought me in contact with him directly, other than in passing, having been in the same place at the same time. I have been appointed to the Commission on Ethics by Governor Lombardo, but similar to the disclosure made by Commissioner Moran, and I'll make mine shorter, I do not believe that I have a commitment in a private capacity to the governor, and therefore I do intend to participate in this matter. With that, let's ask.
I'd also like to make a disclosure. I became acquainted with former Sheriff Lombardo when I ran for Lieutenant Governor. Throughout that time, we became friends. I don't interact with him socially, but he did appoint me to the commission in January of 25. I believe I can be impartial and make decisions related to this. And I did review Canon 2.1 and my commitment in my private capacity under 281A.065.
Thank you. Any others? Seeing none, let's ask the attorneys for the parties to identify themselves.
Good afternoon, Mr. Chair. My name is Colby Williams from the law firm Campbell and Williams. I'm one of the attorneys representing Governor Lombardo.
Thank you.
Good afternoon, Mr. Chair. Samuel Murkovich, Campbell and Williams, also on behalf of Governor Lombardo.
Thank you. And for the commission?
This is Executive Director Ross Armstrong. He's representing myself in the capacity of Executive Director today.
Thank you. Commission Counsel Bassett, do you have a presentation on the proposed stipulation?
I do, thank you. During the 2022 campaign cycle, the commission received and initiated the 2 complaints at issue in this matter regarding then Sheriff Lombardo's use of his uniform and badge while campaigning for governor. An adjudicatory hearing was held before the commission on July 25th, 2023 on the allegations of the complaints. The commission thereafter issued its final opinion, finding that then Sheriff Lombardo committed 4 willful violations of NRS 281A 407, imposing a civil penalty of $20,000 in total and censuring Lombardo. Governor Lombardo thereafter filed a petition for judicial review in the First Judicial District Court, challenging the commission's opinion on various legal grounds. That petition was dismissed by the district court on procedural grounds. The procedural order dismissing the petition was then appealed by Governor Lombardo to the Nevada Supreme Court, which reversed the lower court's dismissal order and sent the petition back to the district court for a decision on the merits. In order to avoid further litigation in this matter, including the expenditure of further time and resources by either party, the commission and Governor Lombardo have negotiated a proposed stipulated agreement resolving this matter, which is now before the commission for approval. The terms of the proposed agreement reached by the parties are as follows. Governor Lombardo will stipulate to 1 non-willful violation of NRS 281A 400 subsection 7. Governor Lombardo will make a $5,000 payment to the general fund for this violation. The pending petition in the First Judicial District Court will be dismissed and this matter will be concluded. The agreement does not include any requirement for ethics trainings like many of our agreements do, because upon being sworn in as governor, Lombardo promptly sought ethics training from the commission for his entire office, and he has sought and has subsequently obtained training for the office of the governor on an additional occasion. A copy of the proposed agreement is before you today for your review and approval. I am happy to answer any questions any commissioner may have about the proposed agreement.
Are there any comments or questions from any commissioners?
Do you, Chair, the ones that are voting in favor of this agreement, do they have comments? I'd like to hear from them. If they have comments.
Any comments in support of or in opposition to the proposed stipulation?
Point of order, shouldn't we have a motion one way or the other?
Yeah.
And then we can go from there to discuss the action, or
We can certainly have a comments on a particular motion.
Yes, Mr. Chairman, I'm
any
prepared.
general comments.
Yes, Mr. Chairman, I'm prepared. This is Commissioner Moran. I'm prepared to make a motion to approve the settlement in conjunction with the consolidated cases, numbers 21-062C and 21-082C, consistent and compatible and harmonious with the settlement resolution presented by both the Governor Lombardo's legal team, as well as our esteemed legal team at the commission.
Do we have a second to that motion?
I'll second the motion, then we can get to discussion.
No, I'd like to make an amendment to the motion.
Vice
And,
Chair Wallen, go ahead.
the motion should be to accept the terms of the stipulated agreement as presented by the parties and direct commission counsel to finalize the agreement in appropriate legal form. Any commissioner wishing to submit any written dissent to the agreement may submit their dissent within 3 commission working days for inclusion with the agreement. 1
I
second.
was gonna add that.
Okay, you want to second that now?
That's okay.
Commissioner Moran, will you accept that as an amendment to your motion?
Yes,
Thank you, Mr. Chairman and Madam Vice Chair. I will absolutely and unequivocally accept the friendly amendment to my motion to approve this particular settlement agreement.
Thank
and
you.
I will second that with the amendments to the initial primary motion.
Any comments or questions on the motion?
Yes. Langton,
Commissioner Langton, please go ahead.
I am opposed to the motion to accept the settlement agreement for a couple of reasons. First and foremost, I think that the original final agreement or decision was appropriate. And secondly, is that in my opinion, and I think many courts have supported it, ignorance of the law is no reason to violate the law. And the third one is when I ran for judge in over 20 years ago, I represented law enforcement, and I asked them if they would help me make a TV commercial where they supported me and they said they could not, and I'm talking about line officers, could not do that because the law said no one is allowed to campaign for a different job or support anyone wearing their badge and uniform. And that was line level officers, some supervisors included. But I think in this case that Sheriff Lombardo unequivocally knew what the law was and has violated it or did violate it multiple times. So I'm opposed to the settlement agreement. Thank you.
Other comments from commissioners? Commissioner Lowry?
Thank you, Chair. There's no legal reason to depart from the original final opinion in this case that was issued in 2023. There are no new facts. There have been no changes in the relevant law. The original order was evaluated, reviewed, vetted, and delivered by a group of seasoned, bipartisan, well-respected ethics law professionals. Close to 12 ethics law professionals participated in that process. This negotiation is a fiction and does not comport with NRS 281A. It reverses a previously rendered final opinion, undermining commission precedent. It renders the term final order meaningless. Thank you.
Any other comments from commissioners?
Mr. Chair,
Vice Chair Wallen.
I am dissenting on this proposed stipulated agreement for some of the following reasons, and I will add more in my written dissent, which I plan to provide. I do not agree that this is a non-willful violation based on the facts of this case, and I don't see where there are any mitigating circumstances as set forth in NRS 281A.775 to change it to a non-willful. The circumstances in the agreement regarding mitigating circumstances are weak at best. I also have trouble with the wording that says that the subject agrees to remit $5,000 to be put into the state general fund for the general good of the people. And the other part that says the $5,000 tender will be made. I've never seen such wording in previous stipulated agreements where the subject is paying a civil penalty. Commission Counsel Bassett, I just want to ask you a question before I proceed. Do we have terms like tender in our statutes?
I don't know that, I don't believe those specific words are in our statute. No, I mean, they're synonyms
Okay,
for.
is it generally civil penalty? Do we have that in our statute?
We have civil penalty, yes.
Okay, all right, thank you. Having served on the commission for over 7 years and having had multiple cases regarding wearing uniforms to support a campaign come before the commission, I find that the law is very clear on the issue, and the commission has treated similar cases to this one the same way. By approving the stipulated agreement, we're not treating similar cases the same now, and we're creating more confusion. Many of the new commissioners who have been appointed since April of 23 have a different interpretation of the law, and some have said that it isn't clear. I'm not an attorney, but when you have disagreements over the interpretation of the law, that is where you look to the courts to settle that disagreement. By settling this case without having the courts resolve it, we are doing a disservice to our public officials and employees, and to the citizens of Nevada. We're adding to their distrust of our elected officials and government instead of trying to restore it. Thank you.
Thank you. Any other comments from commissioners?
I prepared a statement, Chair.
Commissioner Smith, please go ahead.
Thank you. And a little bit of this, it will be a recap more so for any public members that are just joining in on this case. The complaints against Mr. Lombardo began in 2021, which alleged violations of NRS 281A.400 subparts 2 and 7. Later in 2023, the then commission, after conducting a hearing, found that there were several violations of subpart 7, but no violation of subpart 2. As a result, subpart 2 is dismissed and the violation under subpart 7 went forward, which ultimately resulted in the fine. Mr. Lombardo filed a petition for judicial review of the ethics opinion in September 2023 with the First Judicial District Court, which he had a legal right to do. The case was dismissed and appealed on procedural grounds. The case was recently revived by the Nevada Supreme Court, which brings us to present. And please know that this is just a synopsis of the procedural history. A Nevada Revised Statute 281A 400 subpart 7 states that a public officer shall not use government property to benefit a significant personal or pecuniary interest of the public officer. But important here, there is an exception to the rule, which allows a public officer a, quote, limited use of government property if 4 conditions are met. Of the 4, the parties here, the commission and Mr. Lombardo, do not dispute that the first 3 factors are met. So Mr. Lombardo has met the first 3 factors, and the only thing that the parties disputed was whether his limited use created the appearance of impropriety. Putting a quick pin in that, while Mr. Lombardo's appeal was pending, the Second Judicial District Court ruled against the Ethics Commission on an unrelated ethics case that is factually similar to Mr. Lombardo's. The parties, that being the commission and the public official involved there, disputed again whether subpart 4 applied to the photographs of a public official who was campaigning and wearing his uniform and badge. The district court, which was Judge Kathleen Segerson presiding, found in favor of the public official and against the commission, and held that with respect to subpart 4, the same one that's at issue here, that no reasonable person would believe that the candid historical photographs showed an endorsement. And as a result, she found that there was no violation of subpart 7. In other words, she found that if there was a limited use of the government property by the official, that it did not create the appearance of impropriety. So no violation found. While that case may not be binding on the case involving Mr. Lombardo, the facts are similar. It is something that has to be considered when evaluating the merits of the ethics complaint against Mr. Lombardo. Like the district court found in that case, I too have trouble finding that Lombardo's photographs, which depict him in his sheriff's uniform, a position that he held at that time, create the appearance of impropriety. I strongly disagree with that. In my view, there's a risk to the commission in continuing to pursue this case, which could be appealed by one or both parties. If the case had been handed to me in 2021, I would have voted to decline it from proceeding into an unnecessary investigation. It's already gone on for 4 years too long. The proposed stipulated agreement offers closure and cost savings to both sides, as well as the courts. Because of that, I support and vote in favor of the stipulated agreement as proposed by the Commission Council. Thank you.
Thank you, Commissioner Smith. Any others?
I will echo Commissioner Smith's statements, but in a slightly less legal tone. I believe if I had been on the commission when this was initially done, I also would have voted against moving forward with the prior decision. I think Nevada law does not specifically say an officer cannot wear their official uniform when campaigning for office. Instead, it relies heavily on broader prohibitions of using government resources and giving the appearance of official endorsement. I do not believe, reviewing the materials, that Governor Lombardo, then Sheriff Lombardo, was going against that. Furthermore, I think that the overarching aspect of other opposing candidates being able to use those exact images in ads against him also needs to be reviewed. And this is one of the reasons that I have joined the legislative committee on our ethics commission to go to our legislature and try to resolve this ambiguity and some of the issues that have come before this council in a meaningful way. So I am in favor.
Thank you, Commissioner Miller. Anyone else want to
Yes.
make comments?
Dr. Reynolds,
Commissioner Reynolds, please go ahead.
I want to echo the comments of Commissioner Smith and her legal analysis of this. These were some of the questions that I had asked and reviewed and talked to our commission counsel regarding the history of this actions and how we got to where we are. And also looking at the court cases that were involved and that had this issue being dismissed and going against the commission. I think this issue should go forward with our legislative action. I'm going to vote in favor of the motion, but I think there's still work to be done on this. If the commission feels strongly about making changes, that we do make changes. I've worked on many changes with the legislative commission, the legislature, to clarify issues within the law. And I think this is a prime example of an area where we could have an impact and go to the legislative commission and to the legislature with and work with the Sheriffs and Chiefs Association, work with the governor's office to clarify this law. So I think it really needs further action, but today I'm going to vote for the motion that's on the floor.
Okay, thank you. Mr. Moran, did you want to make any comments or should I go ahead?
No, Mr. Chairman, I appreciate the comments made by colleagues Smith, Miller, and Langdon. And looking forward to hearing your comments as well, Mr. Chair.
Okay, thank you. So this is my second time around on the commission. I served on the commission in the late 1990s. As a representative of the commission, I attended hearings on bills that resulted in these changes in 1997, and then as a representative of the governor's office in 1999. It's my view that Commissioner Smith's interpretation of the statute is correct, that is what the legislative intent of the statute was. And I believe that the precedents that the commission has adopted started with law enforcement officers wearing their uniforms to endorse others, not in the course of their own campaign. I think in the case where they are endorsing others, there is a greater argument for the appearance of impropriety if it suggests that somehow the government is actually supporting a particular candidate than there is where someone is running their own campaign. It's perfectly legal for a sheriff to say that they serve as sheriff of a particular county and that that's part of their resume. I believe that showing a picture of that is no different than writing it in words. And in this particular case, the governor's opponent and the news media showed pictures of him in his uniform. I also think that there is a First Amendment right that's involved here when you are campaigning for yourself. And so for all of those reasons, I am going to support this. I think this is a reasonable resolution of this outstanding complaint and a chance to put it behind us and then try to work through the legislature. If the legislative intent has changed over the years, we can find that out and see what changes they would like to make to this particular law. Anything else before I call for the vote? Executive Secretary Saldana, I think we probably should have a roll call vote for this one.
Yes, we could do that.
Okay. So please call the roll.
So Chair Scheer,
Aye.
Vice Chair Wallen,
No.
Commissioner Langton,
No.
Commissioner Lowry,
No.
Commissioner Miller,
You're on mute, Commissioner Miller.
Aye.
Thank you.
Commissioner Moran,
Yes.
Commissioner Reynolds,
Aye.
and Commissioner Smith.
Aye.
Thank you. The motion passes 5-3. So the settlement agreement is approved.
Mr. Chairman, do you mind if I share a few thoughts with both Mr. Williams and his legal team, as well as our legal team at the commission?
Yeah, if you can keep them brief, we have other items on the agenda, obviously, so please go ahead.
Absolutely. Thank you, Mr. Chairman. I just wanted to thank both sides for participating in good faith through this process. It is very, very difficult to come to a consensus, especially when you have a case like this that's drawn out for many, many years. In watching this take place over the last couple of years, the level of legal and professionalism on this particular item was the very top tier, the very highest level. And I appreciate that. It was very nice to see the cordiality between both sides. Mr. Williams' office, obviously on behalf of the governor, and obviously counsel for the commission, Ms. Bassett, and our executive director, both doing phenomenal jobs in the resolution aspect, but also throughout litigation and making certain that we keep things professional and compassionate. With that, Mr. Chairman, I appreciate you allowing me a little bit of time to reflect on all the work the commission did over the course of all these years. Very glad to get this behind us. Very glad for everyone to kind of move forward, push the reset button with the education that we've all absorbed through the process, and hopefully we can all be better people and human beings as we move forward. But again, thank you, Mr. Chairman.
You're welcome. So that brings us to item 5. And council, thank you for your presence here today. Item 5 is the discussion and approval of a proposed stipulated agreement concerning consolidated ethics complaint numbers 24-085C, 24-086C, 24-087C, 24-088C, and 24-089C regarding James Gibson, Justin Jones, Ross Miller, William McCurdy III, and Tick Segerbloom, Commissioners, Clark County Board of Commissioners, State of Nevada. I served on the review panel for this matter, along with Commissioner Miller and Commissioner Langton, and therefore we are precluded from further participating in any proceedings. So I'd like to turn this matter over to Vice Chair Wallen.
Thank you, Chair Scheer. Chair Scheer and Commissioners Langton and Miller served on the review panel for this matter and are precluded from participating in any further proceedings in this matter pursuant to NRS 281A.2204. At this time, I would like to ask if there are any disclosures or abstentions to be made. Commissioner
Yes,
Smith.
Madam Vice Chair, may I go first?
Sure.
Thank you, Madam Chair. Commissioner Moran, I'm making a disclosure in these case numbers involving the former Clark County Commissioner as well as commission members currently. I'm an acquaintance of the commissioners and have met with them independently and individually and occasionally through their service as current former commissioners, mayor, secretary of state, members of the state legislature, and more in my work in the state of Nevada as an attorney. I've known the commissioners in a professional or public capacity for many years. I would categorize our current relationship as professional acquaintances. Under 281A.065 of the Nevada Revised Statutes, my relationship with those subject to the commission is or are not within the definition of a commitment in a private capacity to the interests of another person. Consequently, the relationship does not require disclosure of abstention under the ethics law pursuant to NRS 281A.420. Additionally, nothing in Judicial Canon 211, Code of Judicial Conduct, requires disclosure of abstention pursuant to the manner of my appointment. In fact, Nevada law favors the right of a public officer to perform the duties for which the public officer was appointed and to likewise vote or otherwise act upon a matter. However, in my capacity as a commissioner, I serve in a quasi-judicial role and desire to alleviate any concerns of impartiality. Consequently, I'm disclosing the extent of these relationships. Further, I've reviewed Judicial Canon 211 of the Code of Judicial Conduct, which lists types of relationships and events that require disqualification. I have confirmed that these presented circumstances do not require that particular disqualification. Moreover, I believe I will be fair and impartial in considering this matter and have no actual or perceived bias as and against any of these individuals subject to the commission and its jurisdiction. I don't believe my acquaintanceship with the commissioners would materially affect my independence of judgment or that of a reasonable person in my particular situation, and therefore I will be participating and voting on this matter. Thank you, Madam Vice Chair.
Thank you, Commissioner Moran. Commissioner Smith.
Thank you, Vice Chair. I am abstaining from voting on this item because as it relates to the Clark County Board of Commissioners, I have consulted with Commission Counsel about this matter. In my role on the commission, I serve in a quasi-judicial role. Code of Judicial Conduct Canon 2.11 requires a quasi-judicial officer to disqualify in any proceeding in which impartiality might be reasonably questioned based on, but not limited to, various circumstances listed in that canon, including personal knowledge of or experience with the parties or facts involved in the matter, or an association with a lawyer who participated substantially as a lawyer in the matter during such association. And the disclosure is this. In my private capacity, I work as an attorney for the law firm Pisanelli Bice, which is a civil law firm that pursued a case on behalf of Gypsum Resources against Clark County. That case involved certain Clark County commissioners as fact witnesses that are also the subject of the ethics complaint. While that case is closed, it could be argued that the independence of judgment of a reasonable person may be affected in voting on matters related to these individuals. As a result, having reviewed the Canon 2.11, I'm abstaining from voting on the matter to avoid any appearance of bias or impropriety. Thank you.
All right, thank you, Commissioner Smith. At this time, I would like to go and ask the attorneys for the parties to identify themselves.
Thank you, Madam Vice Chair. This is Ross Armstrong, Executive Director, representing myself in this matter.
Madam Vice Chair and members of the Commission, my name is Bradley Schrager of the law firm of Bravo Schrager, and I represent all 5 of the subject respondents.
Thank you. Executive Director Armstrong, please provide us with your presentation on the proposed stipulation.
Thank you, Madam Vice Chair. In June of 2024, this commission initiated complaints against the subjects in this matter following media reports and backup documentation obtained by the commission. When it initiated the complaint, it directed me to investigate potential violations of NRS 281A, section 401, 400 subsection 2, and 421 and 3. Those are the gift prohibitions, the prohibition against unwarranted benefits, and the ethics laws disclosure and abstention rule. We proceeded with an investigation, and key facts determined during that investigation is that with the exception of Commissioner Gibson, all of the commissioners only used one night of the 4-night ticket. The Las Vegas Grand Prix organization did provide 4-night access tickets. In addition, we investigated if in a meeting after their attendance at the event, they failed to properly disclose and abstain on agreements between the Las Vegas Grand Prix and Clark County. We confirmed that no disclosure occurred during the investigation. We also determined that the county did complete an after action report following the event that was completed by the county for commissioner review, and that specific commissioners did perform some ceremonial duties such as waving a flag at the finish line. Given the totality of the investigation, this case was presented to a review panel of 3 commissioners in July of 2025. At that review panel, the commission they dismissed the allegations of 402, which is unwarranted privileges or preferences prohibition, in part because it was determined that there were some legitimate reasons for the commissioners to attend the large scale event. As we prepared information for the panel on that front, we took a look at what other states do, and many other states have statutes specific to ceremonial attendance of events that provides guidance on how those types of events can be attended. We don't, in our Nevada ethics law, have anything like that. We also have no ability to create such rules by regulation. But we did believe that that ceremonial role, educational role for these commissioners did kind of undermine the allegation that this benefit was unwarranted. This was not a situation where the commissioners were like at the event, taking a bunch of friends, partying for 4 nights. They were there on specific duties. And so partially for those reasons, the allegations of 402, those were dismissed at the review panel. In addition, there was a split vote on whether the tickets violated 400 subsection 1, the gift prohibition, a 2-1 vote on that. So what did go forward were the allegations of disclosure and abstention, and then the gift prohibitions. After the review panel, the parties participated in a settlement conference with Commissioner Langton, and we were able to reach an agreement that we bring before you today. As executive director, when I look at bringing a negotiated stipulation to the commission, I try to identify which of the conduct that occurred has the most important public policy implications and our goal of good government at issue. And so in this case, we have a gift of 4-day pass to the event, but we also had the failure to disclose that gift when the matter came before the commissioners again. And so for me, as we sought to negotiate this case, the biggest public policy issue was that failure to disclose. The ethics law says there are certain, gifts and relationships you can have. You don't lose your humanity just because you're in public service. But if you receive a gift, or if you have a relationship, and that person who gave you the gift, or that person who's a relation comes before you to make a government action, that you need to disclose that relationship. You need to disclose that gift, right? Because then if you don't, these gifts are in secret, and secret lends itself to impropriety. And so for those purposes, or for those reasons, we bring before you this negotiated resolution, which has each of the commissioners agreeing to a single violation of section 281A, section 421, the failure to properly disclose, for failing to disclose the gifts at their November 21st, 2023 meeting. When you take a look at the abstention piece of that, the threshold for abstention is higher than disclosure, especially if there's a disclosure. In this case, the matter before the county commission in November 2023 was the Las Vegas Grand Prix actually paying the county for purposes of services provided during the event. And so therefore, we're focused on the disclosure here today. That public officials need to disclose gifts they receive if the gift giver comes before them, and that then it's up to the people to decide and judge the conduct of those public officials. The agreement between the parties is that the single violation of 420 subsection 1 shall be deemed non-willful. This is in part because of the lack of history of ethics violations of the subjects, their cooperation during the process, their willingness to admit to the violation today, and their genuine interest in pursuing systemic change in Clark County to help restore public confidence. And we'll talk about that with the stipulated conditions. So again, the agreement today is that the violation will be deemed non-willful. Each of the commissioners has agreed to work with Clark County government to establish an ethics officer for the county with the authority of an assistant county manager level position. In addition, each of the commissioners will work with the county to adopt an event attendance policy that will establish rules about ceremonial or educational attendance at events. And each commissioner has agreed to receive an admonishment from this commission, which by law is a written expression of disapproval of their conduct. This agreement makes it clear that it is unacceptable to receive gifts and then fail to properly disclose them on the record at the time the matter is heard, when the gift giver is before them. It also helps place guardrails up for Clark County officers and employees to reduce the likelihood of similar violations in the future. And for those reasons and with those conditions, I respectfully request that you accept the stipulated agreement of a violation.
Thank you. Attorney Schrager, do you want to add anything to this comments before I open it up to commissioner comments and questions?
Thank you, Madam Vice Chair. I'll be exceptionally brief and just say that this resolution is the product of lengthy and intense discussions over more than a year, entered into in very good faith by both sides that involved a recognition of the strengths and weaknesses of each position. I think that the resolution agreement reflects the strengths and weaknesses of each side's positions, and that the potential for establishing an ethics officer and further policies will also serve the commission's goals of ensuring compliance in the future and clarifying the application of the rules as they exist to situations as they arise going forward. So I would also urge the commission to accept and approve the good faith stipulation that's been entered into.
Thank you. All right, I will open it up this time. Commissioner comments, Commissioner Reynolds,
Well, I'm gonna,
or questions.
actually, I'm gonna make a motion to accept the
Okay.
terms of the stipulated agreement as presented by the parties and direct the commission counsel to finalize the agreement in appropriate legal form. Any commissioner wishing to submit any written dissent to the agreement may submit their dissent within 3 commission working days for the inclusion into this agreement.
Okay, is there a second?
Yes, Vice Chair, I can support a second on that motion. Thank you.
All right, comments, questions?
I have a comment on
Commissioner
this.
Reynolds.
I agree with the stipulated agreement and specifically the portions of notice. I think that is an appropriate step that was missed by the commission. One of the things, though, I think is important to realize is that with any large scale event, the F1 event was a very large scale event for the commission. There was a substantial investment into that event, as well as events like the Super Bowl. I was a city manager for 20 years, very aware of special events and attendance by either council or commissioners for that. I think we seriously should look at an exemption for these types of events. Easier said than probably done in terms of how that's structured, but I think it's appropriate here. I think it's the duty and responsibility of commissioners to be involved in the event, to see the event, because they're making decisions. The community is making decisions on how the event is conducted, everything from transportation to access to substantial improvements in roadways to security, multiple types of issues that occur when you have a substantial event within your state. So with that, like I said, I'm in favor of this, but I think that for future look at our legislative program, we ought to be looking at an exemption for these types of events. So that commissioners, city councilmen, or other people substantially involved in these events can go to the events and see what's going on.
Thank you. Commissioner Lowry, do you have comments?
Thank you. I want to note that I appreciate that the commissioners did not attend the 2024 F1 functions while this case was being worked out on both sides. I think it speaks to their good faith and to their respect for the Ethics Commission and its interpretations of the law. That is not always the case. When cases are brought, there are times when the subjects continue to engage in the behavior that the commission has identified as prohibitive. So for these commissioners to work in good faith, to stay away from the 2024 races while it was resolved, I think is certainly to their credit. An observation, Executive Director Armstrong, one of the factors in the stipulation that looks to make an ethics officer at an assistant county manager level. Here's my concern with that. Elected officials do not report to, have to listen to, be directed by assistant county managers. They just don't. Pragmatically and in the real world, they can hear them out, but there is a huge imbalance of power there. And so I think it's going to take a tremendous showing of good faith on the behalf of the electeds, because you're not going to have elected officials being told what to do by assistant county managers. I appreciate the effort on behalf of Clark County, and am hopeful that it will be a joint effort by the electeds and county leadership. But anything that you can do, Mr. Executive Director, to nuance that so you get the hoped result would be great. Thank you.
Thank you, Commissioner Lowry. I will note that in item J of the terms and conclusions of law, I didn't talk this, I usually just talk about what the other person's required to do. But we note that the executive director agrees to provide technical assistance, again, if requested, to Clark County for the development of that officer position and the event attendance policy. And I will tell you, without disclosing the entire breadth of the negotiations, that the idea of an ethics officer within Clark County first came from them. It did not come from me, which I showed good faith in making that system work.
Commissioner Moran, any comments, questions?
Yes, no, thank you, Madam Vice Chair. I would just say a few things. One, I appreciate again, Council Bradley and our Commission Counsel, Elizabeth Bassett, and our Executive Director's hard work in coming up with a resolution that is not zero sum, where both parties benefit. And at the end of the day, the net win for everyone is education and ethics. And I wanted to say thank you for that work. It makes it much more easy for us, certainly more palatable for me to see that type of work and with one another as colleagues on items that can be in some circumstances adverse to one another. The second thing I wanted to say is, these individuals that are the subject of this particular matter, former Commissioner and former Secretary of State Ross Miller and the other members of the commission from, members Segerblum and the others, these are exceptional public servants. These folks have dedicated their entire lives to public service and making certain that we all have a nice place to work and to do business and to raise families, most importantly, whatever they look like. And I wanted to, recognize that, congratulate all of them. That job and the job that they do day in and day out is 24/7. And I am certainly appreciative of all of their hard work, again, to give us the very, very best quality of life in Southern Nevada in particular, but in general, the state of Nevada. And last item, obviously, is the educational component on this particular item. And I feel that this has been a learning experience for all of us as it relates to F1 in the marketplace, bringing new sport and entertainment, hospitality to Las Vegas and the state of Nevada. And I think that I appreciate their efforts in ensuring that this type of an event is rolled out correctly and seamlessly and compatibly and in harmonious with the other business owners and landowners in the area. But again, I wanted to point that out. I'm in favor of this motion, obviously, via my second. And I appreciate the hard work that everybody has done to make this a reality. And to conclude this aspect of commission business. With that, Madam Vice Chair, thank you.
Thank you. Executive Director Armstrong, I kind of struggle with this case in some ways. So I've got some observations, questions here for you, and I couldn't tell in the materials. So did these tickets allow them to take a guest? Did they take guests with them?
No, these, Executive Director Armstrong, for the record, these tickets did not allow them to take guests with them. This was just for them.
Okay. And in here, you know, it was to talk about education. So why did they have to have a ticket to go behind the scenes? It wasn't open to the public. I'm struggling with that. I mean, if they're doing ribbon cuttings, taking tours of the facilities and all the safety things, why do you have to have a ticket for that? That should just be a given.
I think that's a great question from a practical matter. I think that I'm not going to try to speculate on why the Las Vegas Grand Prix structured this access the way they did. They could have easily said it will be one night where there'll be no ticket and you show up on this day and you have special access. You know, I think they probably wanted to create an accurate record of the particular value of what was being granted. I don't know if they had in their structure, you know, this was like their only option to give to people within their own internal policies. So, and in part that is why you see the 402 come away at the panel stage, is that there's a way to allow these county commissioners to attend and experience the event in that educational way without giving a 4-day like all access pass, right? That was, they could do it in a better way that would not raise so many ethical issues. And so, and you know, there were, you know, throughout the course of the investigation, there were notes that certain commissioners had questions about like sustainability and how does the recycling work and those. So for us, there was evidence that there was that educational component. It wasn't just here's a blanket ticket, go do whatever you want. Their access was controlled. There was a specific place they had to meet. They were then shuttled. They then were escorted through each of the areas to show what it was like. And so that's, you know, that's one of the conclusions of the investigation, is that yes, they got this ticket. There's probably a better way to provide that experience than a 4-day pass to the event.
It seemed to me like there definitely was an educational purpose to it. So following up with that, since all of the other commissioners only went for 1 day, correct?
Correct.
Except for
Commissioner Gibson was one.
Gibson was the one who went for 4 days. So I don't have a problem with the other 4 because they were getting educated. So can you explain to me why his going 4 days was justified for the education?
For what I found persuasive as we went through the process is that Commissioner Gibson at that time served as the head of the LVCVA, which was the main sponsor of the event. And so he was the head of that sponsoring event. And he also, you know, since he was there, we were able through the investigatory process to interview him. He offered to sit for an interview and talk, and it was clear that like each of those days he had specific tasks related to his duties, both as a county commissioner and as the chair of the LVCVA.
Okay, that kind of clears things up and it's giving me better comfort. That correct. I don't see any other comments. So with that, I will entertain a motion, or I will ask for a vote. Sorry, we already did the motion. Commissioner Reynolds already did that for us. So all those in favor say aye.
Aye.
Aye. Any opposed? Right, hearing none, motion carried. Attorney Schrager, thank you so much for participating, and thank you so much for your clients working very well and with our staff to get this matter put to bed and taken care of. We appreciate it. Thank you.
Thank you very much, Madam Chair. I want to especially thank the Executive Director and Commission Counsel, and also Commissioner Langton, who was a fair but firm mediator for our session. So thank you all.
Thank you.
Thank you, Vice Chair Wallen. Appreciate that. I think that brings us to item 6. Discussion and approval of a proposed stipulated dismissal agreement concerning ethics complaint numbers 24-036C and 24-050C regarding Devin Reese, City Councilman, City of Reno, State of Nevada. Commissioners Langton and Reynolds served on the review panel for this matter and are therefore precluded from participating in any further proceedings pursuant to NRS 281A.220 sub 4. Will the attorneys for the parties please identify themselves? Executive Director Armstrong?
Executive Director Ross Armstrong on behalf of myself.
And do we have counsel for Mr. Reese present?
Yes, good afternoon, Chairman Shearer. Rick Shue with the Mop and Cox Du Bois Law Firm on behalf of Devin Reese.
Thank you.
And sorry, I was gonna say, Mr. Chair, for the record too, Mr. Reese here is he is present in the room.
Sorry about that.
Excellent, thank you. Executive Director Armstrong, please go ahead and tell us about this proposed stipulation.
Thank you. In March and April of 2024, the Commission received 2 separate complaints, primarily focused on travel of Mr. Reese, alleging that it violated the ethics law. The Commission accepted jurisdiction of that matter and ordered an investigation. In September of 2024, after a response from Reese and a chance to provide documents and evidence, a review panel of the Commission determined there was sufficient cause to refer the matter to the Commission. The parties then engaged in the discovery process, which includes requests for documents, admissions, interrogatories, depositions. During that discovery process, Reese provided new additional documentation and witness information. And upon review of that information and all of the other information collected during discovery and the investigation, I came to the determination that there was not sufficient evidence to deem that there was a violation by a preponderance of the evidence. There were lots of questions in the complaint about the wisdom of some of the travel, the need for some of the trips, a lot of issues that are beyond the scope of our commission in terms of things that are at the discretion of the local agency. Our focus in that investigation and discovery process focused on days of city reimbursement where there was no evidence of public or city business occurring. And so the evidence that was revealed throughout the discovery process is that there were justifications and evidence of city business on the days that were previously in question. There are still questions about some of the reimbursements, and there are probably likely, as we saw with the public comment questions about the appropriateness of how the city sends its public officials on travel. But again, our focus was simply on 400 subsection 2, which says a public officer shall not receive a privilege or a benefit without justification or adequate reason. And during that discovery process, I came to the conclusion that there was appropriate justification for the travel that was in question and the reimbursements that were made. And so we're asking the commission at this point to approve this dismissal and to close this matter.
Thank you. Just a quick question there. So to clarify, so it's your view that the evidence shows, once you got all the evidence, it showed that there was city business conducted on all of the days in question, even if some might disagree with whether that was legitimate city business. It was city business that the city of Reno determined was appropriate for it to conduct, and that is outside of the scope of our particular authority.
That is correct. That there was evidence that there were either meetings or events that Mr. Reese attended, or it was a travel day to get to the East Coast in time to attend those events in the morning. And so I came to the conclusion that there was not an unwarranted benefit that could be proved by a preponderance of the evidence.
Are there other comments or questions for the executive director? Well, first, let me ask Mr. Shu, do you have any comments you'd like to make before we move into commissioner comments?
Thank you, Mr. Chairman. I think Mr. Armstrong summed it up. This is not your typical settlement where there's like a plea bargain for a lesser charge based on risk. This is what we had requested, and Mr. Armstrong graciously agrees that this is the type of case that should not go to hearing after getting all the evidence. And I think it saves all the taxpayers money, and it saves you as commissioners your valuable time too. But thank you very much.
Okay, thank you. Questions or comments or a motion from any commissioners?
I'll make the motion. I move to accept the terms of the stipulated agreement as presented by the parties and direct Commission Counsel to finalize the agreement in appropriate legal form. Any commissioner wishing to submit any written dissent to the agreement may submit their dissent within 3 commission working days for inclusion with the agreement.
Is there a second to that motion?
Mr. Chair, I can support that as a second.
Okay, second from Commissioner Moran. Any other comments or questions on the motion? Commissioner Lowry?
Executive Director Armstrong, I'm a little perplexed. And correct me if I'm wrong, because maybe I didn't read it correctly. Did it take a year for you to get the supporting documents that led you to this conclusion?
I would have to do the math on the timing, but I'll give you the kind of the quick rundown is that this, this case came to our attention in March of April of 2024. We started the investigation in May of 2024. Through his counsel, resubmitted a response on July 10th, 2024. And then we went to a review panel in September. So, the notice was issued on May 2nd, and it was at depositions. I don't have the date in front of me now, but it's late July, early August.
August 11th.
Where that information became clear and then was subsequently provided by Reese at that time. So yeah, it was a year from the time that we got the written response to getting that information. I will say there was some time in there because there's another matter that is the next matter on the agenda where the parties did attempt like a global resolution. And so there was some lag time there where there was no discovery process or really working towards providing additional information on the case. But that is correct. So it was August of 2024 when that information came through.
You mean August of 2025?
2025, I'm sorry, yeah.
So why would we not have expected the travel documents and supporting documents? Why would we not have expected them prior to the review panel? If they were notified in May of 2024 and the review panel met in September, that was several months to pull those supporting documents together. And one would expect if the supporting documents were there, the review panel would have just dismissed the case, but they didn't, because they didn't have the documents that you didn't get until a year later. Correct?
Correct. So I will say that it's always helpful to have all of the information that a subject possesses before that review panel, so that we can present the review panel a complete picture. That didn't happen in this case. I will tell you from the investigation, during the dates of time where this travel occurred at the city of Reno, the travel process was not well executed, that there was lots of confusion about that travel process. And so those documents weren't included in the original backup and not provided by the city when we did a public records request. And so I certainly would have preferred it all prior to a review panel. It would have cut short a lot of work, but no matter the timing of evidence that is exculpatory for the subject of investigation, we bear the burden. I bear the burden in terms of being the state to not take a case all the way to you if I can't prove it by the standard that you have.
Thank you.
Mr. Chair, may I elaborate on that question, the answer?
Sure, Mr. Shu.
Yes, Mr. Chair and Commissioner Lowry. Part of the challenge was that there was a transition in the computer system, especially the calendaring system with the city of Reno, which Mr. Reese didn't have access to. And therefore, in terms of dates, they were not on the calendar because those documents could not be retrieved. So there was a longer process that occurred later on during this investigation and during discovery, where we had to reconstruct and try to find other types of corroborating evidence to show that Mr. Reese was where he was, which convinced Mr. Armstrong to conclude that these were legitimate days for travel. But that was the challenge, is that we didn't have that. We couldn't access that. And with respect to other delays, as Mr. Armstrong had said, there was a time period for a mediation process. There was also written discovery. There was also a delay with respect to setting up depositions of the former city manager in August and Mr. Reese. Now, keep in mind, Mr. Reese had not been interviewed before the just and sufficient cause hearing. So I don't have any control over how that occurred, but there were legitimate reasons for the delay. Thank you.
Commissioner
Thank you.
Shu?
Yes, is that Vice Chair Wallen?
Yes. Mr. Shu, I'm still kind of struggling with this, all right? And Commissioner Lowry elaborated on a lot of concerns that I have. So you submitted a response in July of 24. So your response was, well, we don't know, or what was your response, I guess?
Sorry, I just want to be very careful that a subject's response is confidential by law and not permitted to be disclosed.
Okay, all right. Well, then with that being said, okay, as a CPA and someone who does audits, if I encountered a situation like this, that it was over a year before the information that I had requested finally came to me after we had said, oh, this other agreement that we have entered into with you is going to be thrown out, and then all of a sudden the information comes before me, I would be very suspicious of it. And so I'm having a really tough time here now. And I'll probably end up voting no on this because, one, the information came so late. Okay, I think there were opportunities to kind of work sooner to get things done. You could have asked for an extension of time if you didn't have the information because you're going through this whole new computer change, right? And also because of the ransomware attack on the state, I don't have access or privilege to go and look at the responses that were submitted at this time. So I'll probably vote no on this.
Vice Chair Wallen, did you make this motion?
I made the motion, but in listening to Lowry and thinking about it, I mean, the motion can still stand the way it is.
Okay. Are there any other comments from commissioners? I just want to have a question, Executive Director Armstrong. There was other corroborating evidence in this particular case. It wasn't simply the deposition of Mr. Reese, but there was also a deposition of the former city manager, as I recall, and an affidavit from a third party that corroborated those statements. Is that correct?
That is correct, Mr. Chair. There's a deposition of who was the Doug Thornley, who was the city manager at the time, who corroborated the purpose of some of those dates that there was no documentation for. And the city's lobbyist in Washington, D.C. Helped confirm some of the statements that Mr. Reese made during his deposition about scheduling visits at on the Hill and those DC trips that were in question. So it was not just the deposition and statements of the subject, but evidence and corroboration thereafter.
Thank you very much. I must admit that I share some of Commissioner Lowry and Vice Chair Wallen's concerns that it did take so long, that there was even resistance to discovery, to the point that there had to be a motion to compel that was made. I think a lot of the commission's time has been taken when this evidence could have and should have been produced earlier. I'm also concerned by the city's process, which has the city manager approving travel for the council members when the city manager reports to the council. And I would ask that the city take that into account going forward as they design their process. It's not for us to say what their process should be, but it does give me some concern of potential conflicts in that process. Having said that, at the end of the day, the evidence is what it is. And if there's not sufficient evidence to show a violation, then I agree that with Executive Director Armstrong, it is incumbent upon us to not go forward if the evidence is simply not there. So I will support the motion. Any other comments or questions before I call for the vote? With that, all in favor of the motion to approve the settlement, please say aye.
Aye.
Any opposed?
Opposed.
Okay, so we have 4 in favor, 2 opposed. So the motion passes. And that matter is approved. That brings us to the final matter the final substantive matter on our agenda today. Item number 7, discussion and approval of a proposed stipulated deferral agreement concerning ethics complaint number 22-104C regarding Devin Reese, City Councilman, City of Reno, State of Nevada. Commissioner Lowry served on the review panel for this matter and is precluded from participating in any further proceedings pursuant to NRS 281A.220 sub 4. Also, Commission Counsel Bassett was associate counsel and prosecuted the case at that time. So it's my understanding the Deputy Attorney General Olson will be sitting in for her for this particular matter. Do any commissioners have a disclosure they would like to make on this item?
Yes.
Commissioner Langton, please go ahead.
For the record, this is Michael Langton. I had to abstain in the matter. I have in my law practice known and dealt with Mr. Reese and his law firm multiple times, and I must on that basis abstain.
So will the attorneys for the parties please identify themselves? Executive Director Armstrong?
This is Executive Director Armstrong on behalf of myself.
And
Jonathan Shipman, City Attorney's Office, representing Mr. Reese in this matter.
And Mr. Reese, just let the record reflect Mr. Reese is still present.
Yes.
Yep.
Okay. Executive Director Armstrong, please go ahead and tell us about this proposed stipulation.
Thank you, Mr. Chair. In September of 2022, the commission received this ethics complaint regarding Councilman Reese. The commission investigated allegations of 400-239 and NRS 423 regarding disclosure and abstention. During that process, the we took the case to a review panel. Now, that review panel found that there was credible evidence to support a determination that just and sufficient cause existed for the commission to render an opinion as to the potential violations of 420 subsection 1 and 3. That same review panel believed that the issues that were identified in terms of ethics compliance could be dealt with through a deferral agreement instead of a referral to the commission for a violation. Reese agreed to the deferral agreement. It required continued compliance with the ethics law training within 60 days, development of a conflict checking system with his employer, and submission of city council meeting minutes showing proper disclosures. Reese complied with all parts of that deferral agreement. However, the case that was just previously heard was referred by a review panel, and therefore this commission found in January of this year that the deferral agreement should be revoked and that we should proceed to a hearing on these matters. Because, and the sole basis of the revocation of that deferral agreement was that the other cases that we just dismissed had gone beyond a panel. And so as it became clear that those two other cases should be dismissed, we engaged with Mr. Shipman in terms of what should happen in this particular matter. And the parties have agreed that with this stipulation, the commission should reinstate its deferral agreement with Mr. Reese and that it should be effective on the date that it was revoked earlier this year. With the deferral agreement being effective on the same date that it was revoked earlier this year, the time that was required for Councilman Reese to complete his deferral agreement has passed. And so we would ask that you dismiss this case noting compliance with the deferral agreement. So the ask in this stipulation is that you reinstate the deferral agreement, noting the dismissal of the other two cases, that you determine that Mr. Reese complied with the deferral agreement, and that consistent with the original agreement and the terms of this stipulation, the case now be dismissed.
Thank you. Any comments, Mr. Shipman?
No, Mr. Chair, I think Mr. Armstrong summed it up quite well. Thank you.
Thank you. Any comments or questions or a motion from commissioners? Do we have a motion then? Commissioner Miller?
I will make a motion.
Okay. Do you want to, the standard form would be to accept the terms of the stipulated agreement as presented by the parties and direct Ms. Olson of the Attorney General's office to finalize the agreement in appropriate legal form. Any commissioner wishing to submit any written dissent to the agreement may submit their dissent within 3 commission working days for inclusion with the agreement.
Thank you for the friendly amendment.
Yeah, you're welcome. Do we have a second to that motion?
I'll second the motion.
Okay, Commissioner Smith seconds. Any other discussion? All in favor, please say aye.
Aye.
Aye. Any opposed? I think that passes then unanimously. Thank you, Mr. Shipman. Thank you, Executive Director Armstrong. Thank you, Mr. Reese. Appreciate your time today. And with that, that'll bring us to item number 8. Item number 8 is commissioner comments. Do we have any comments from commissioners about future agenda items or other matters relating to the commission?
Chair.
Vice Chair Wallen.
I just have a comment here. Today has not been a great day for the commission. Our mission statement is to strive to enhance the public's faith and confidence in government by ensuring that public officers and public employees uphold the public trust by committing themselves to avoid conflicts between their private interests and their public duties. I feel like we kind of strayed from that. We also did not follow our first guiding principle, which is our highest priority is to protect the citizens of Nevada by interpreting and enforcing the provisions of the ethics law in a fair, consistent, and impartial manner. In some cases, I feel that we were not consistent in changing how we've interpreted the law before. I just hope that as we go forward, we come back to following our guiding principles and our mission. Thank you.
Thank you. Any other comments from commissioners? Seeing none, that brings us to item number 9, which is public comment. Executive Director Armstrong, have we received any other public comment by email during the course of the meeting?
We have not received any public comment during the course of the meeting.
And are there any members of the public who are attending in person or virtually who want to provide public comment?
Yes, Mr. Chair.
Yeah, please go ahead. Identify yourself for the record.
Thank you so much. And let me just confirm that I am where you can see and hear me. My name is Devin Reese. I'm a Reno City Council member.
Yeah, I can see you in the distance, but I could not identify you.
Thank you so much. Mr. Chair, Vice Chair, and Commissioners, thank you again for today's dismissal. It confirms what I knew from the start, that I was innocent of the charges. I am grateful to finally have my name cleared and grateful to the Commission Council who, through its review, has shown that truth had prevailed. But let's also be honest about what happened here. For more than a year and a half, my name has been dragged through the mud, not by evidence, not by findings, but by headlines and blog posts. One public commenter here today had the audacity to amplify them as if they were fact. That is not oversight. That is weaponization. A sacred tenet of American jurisprudence is the concept that people are innocent until proven guilty. This proceeding flipped that presumption and made me out to be guilty until proven innocent. That is wrong, Vice Chair Whalen. Mr. Armstrong, the playbook is familiar. File a complaint, push it to the press, create a headline that says under investigation and let the damage take root, and then post and reshare it on Facebook, Nextdoor, and Reddit. Then months or years later, when the case is dismissed, the truth arrives too late. Mr. Armstrong, shame on you. You aggressively pursued this matter. You did so without complete and accurate information. Your investigator spoke to me for 15 minutes. There was no follow-up, and several key witnesses were never interviewed. Every witness for the city verified my innocence and confirmed that I was owed money from the city's audit. My lawyer and I gave you multiple opportunities to right this ship, and you chose to ignore them. In this room, you had the audacity to tell commissioners that I stole from the citizens of Reno. Sir, I have never stolen anything in my life, and how dare you say that about me? I am a father, a husband, a 25-year member of the Nevada Bar, and I deserve better. You also had the audacity to try and extort me into a settlement by threatening to refer me for criminal prosecution. This is an issue that I will address with the State Bar of Nevada. Vice Chair Whalen and Commissioner Lowry, your votes create another headline without legal basis. I always maintain my innocence. The city provided everything it possessed at the time the request was made. I had no independent way to provide additional documentation, nor was I required to. During discovery, as always happens, I was asked for specific additional documents, and those were provided. This has to change. The Ethics Commission is a vitally important, and when it works very well. But when it allows itself to be manipulated, it has become broken, not just for me, but for every public servant and every Nevadan who deserves both accountability and fairness. So yes, I'm grateful for today's decision, but I'm also saddened by how long and how needlessly this dragged on. I am also aghast at how much money was spent to obtain a complete vindication. And I hope going forward, we will fix what is broken and restore this commission to what it was meant to be, a guardian of ethics and not a pawn in political games. Thank you very much.
Thank you. Is there anyone else who'd like to make public comment?
Even though I'm a commissioner, can I make a comment?
Certainly.
In each and every dealing I've ever had with Executive Director Armstrong or with Vice Chairman Wallen, they have been very, very dedicated to the law and the facts. And I think they have done an outstanding job in all their dealings with the commission and concerning all complaints that we've been involved in since I've been on the commission. Thank you.
Yes, Mr. Chairman.
Commissioner Moran.
If you don't mind, I'd like to make comment as well. I I would say the same thing. I would echo the remarks of my colleague. I do also believe, having worked with the executive director for some time now, several years, I feel that he is fair. He's got an open ear for all sides. We've been in opposition on certain items. We've been joined on certain items. He's always maintained his professional stance. He's always maintained and preserved the integrity of his job. And I take issue with the fact that somebody would call him to the mat like this, because the only thing I've observed is exceptional professionalism. And so you will never see me speaking in public comment. But this time I felt I could not help myself because I don't want to see someone suggest something on the record that is not something that I've experienced in working with him professionally and personally. And so I take significant exception with the comments that have been made on the record, and I'm very upset about that.
Thank you. Do we have someone else there in the room that wants to make public comment?
Yes, Your Honor. Yes, Chairman, sure. Rick Hsu. I just want to make a quick comment here. Obviously, my client it's been a trying process for him to go through, but I don't know if everyone here knows, I served on this commission from 2000 to 2008. I was this commission's chairman for 18 months. And when I read some of these blogs and articles that come out and that get sent to this body, it's shocking. But one of the things I want to address is that there's a notion that this commission is somehow feckless, it is toothless. And back in 2000, when I was appointed, that there may have been some truth to that. But today, the powers have shifted dramatically through legislation, and to the point where if you are accused of ethical violations, it becomes a war of attrition. It deters good candidates for running for office. Our government is a citizen legislator type government, and therefore I would invite a discussion with perhaps Commissioner Miller, since he's on the Legislative Commission, or you, Chairman Scherer, to go through and discuss some of the challenges that you encounter if you're representing a public officer who is a subject to this investigation. It is challenging. It is highly expensive. The way the laws are written are stacked in some ways with a veil of secrecy. And I would welcome any of you to have a discussion, have a cup of coffee, go through it. I'd be happy to go through and point out some of the problems that has really shifted and turned the tides with respect to the power of this commission. Thank you very much.
Thank you for your comments. Any other members of the public that would like to make comment?
There's no one here in Reno.
Okay.
What about Zoom?
And there's no one on Zoom that has indicated they wish to provide public comment.
Okay, and then since we had some commissioners make comment, any other comments from commissioners? If not, I will simply say that the reason that the review panels were put in place in 1999 was to try and address the situation where, and the reason confidentiality was put in place was to address the situation where one party would file a complaint against a public official and then immediately publicize that complaint and make it subject to an open records request and use it to hurt that person politically. The review panel process, the confidentiality was put in place so that complaints would be confidential until a review panel actually found that there was just and sufficient cause to go forward with that complaint, to try and weed out some of the more frivolous complaints and allow public officials to not have their names smeared when there was no merit to the complaint. But that does involve, when there's an investigation, there is an obligation of public officers to step forward and provide information so that the review panel has that information and can consider it when deciding whether there is just and sufficient cause. I echo the comments that were made earlier. My experience with Vice Chair Wallen and with Executive Director Armstrong are that they are professional and that they act in what they truly believe is the best interest of the state of Nevada. That doesn't mean we always agree on everything, but I have never questioned their motives. And to Mr. Shu, if he's still in the room or if he reads this or watches this later, I'm happy to hear any suggestions for improving the process. But I think it's, as I said, I think in 1999, there was an attempt to improve the process, and by putting the confidentiality in, that was one of those steps. So I don't know how we necessarily improve it by removing that, the confidentiality, and allowing anyone that wants to broadcast a complaint before there's ever been a determination that there is in fact just and sufficient cause for that complaint. With that,
I'd just like to echo that I'm willing to make myself available. Since joining the commission in January of this year, it's been my experience that we have been efficient and effective of dealing with the issues that come before us. And I do understand the need for a legislative committee to continue to clarify ambiguity in NRS. So we can better do our job, and those employees and candidates and elected officials have clarity in the matters related to ethics.
Thank you. If there's no one else, then I believe we are at the end of our agenda, and I would accept a motion to adjourn.
So moved.
Moved by Vice Chair Wallen. Do we have a second?
Second.
Seconded by Commissioner Langton. All in favor?
Aye.
Aye. We are adjourned. Thank you so much for your time today.
Thank you.